Can you register a trademark when there is already a service mark on it? That's the question I'm answering today. I'm Aaron Hall, an attorney representing business owners in Minneapolis, Minnesota. Let's imagine that you want to register a trademark with the U.S. Patent and Trademark Office. That would give you a federal registered trademark. But there's already service mark out there. Does that pose a problem? And if so, what do you do about that? That's the challenge we're tackling today. All right, so what is a trademark? Let's start there. A trademark is a name, a term, a logo, a mark, whatever it is that is being used in association with selling goods or services. Now, so for example, think about the Nike shoe. Nike, you hear Nike, you think of the shoe company. When you see the swoosh, which is the Nike logo, you think the Nike shoe company. You probably don't think, oh, is that lightning on the shoe? Is that a wave? No, you see the image and you go, oh, that logo represents a company called Nike, they sell shoes. Same with the word Nike. So those are examples of trademarks, the swoosh and the word Nike, because they show an association between the source or goods and the source of those goods, the company Nike. But I also said the source of services. So Nike primarily sells goods, that's products, shoes, but you can also do a trademark for services. And technically, that's called a service mark. So a trademark is for goods and products. A service mark is for services. Services like a law firm, a laundromat, a painter, a mechanic, a realtor. All these things are examples of services. So imagine that you want to register a trademark, but somebody is already using it for a service. The question comes down to two issues: trademark infringement and trademark dilution. Let's talk about trademark infringement first. Is the term, the mark that you're going to use, confusingly similar to what the service company is already using and in the industry they're in? So let's take a simple example here. Let's say it's a real estate company and they're called Whitewater Real Estate, and you want to have a clothing company called Whitewater Clothing. Well, those are significantly different. I don't think, in my mind, if you were to ask me, I don't think if I heard Whitewater as it relates to real estate that I'd be like, oh, that sounds like Whitewater Clothing. They're probably the same company. So that's the trademark infringement question. Are they confusingly similar? Would a member of the public, a reasonable person, think that they're somehow similar enough and from the same company? The second issue is trademark dilution, and it's a very similar analysis, but the question is, are they confusingly similar enough that although they might not be confused as the same company or the same source, would they be confused as somehow related? For example, let's say I wanted to create a company called Mercedes Computer Company. Well, Mercedes Car Company, I don't think, sells computers. So you might think, hey, it's different enough, it's a whole different industry, it's not confusingly similar. You might say that. However, because Mercedes is a very unique term, and a term that is so well known throughout the United States, Mercedes at least would have a claim for trademark dilution. Basically saying, look, even though nobody thinks your little computer company is related to us, a premium car company, you're ruining the word Mercedes, or you're diluting it, you're devaluing that term. And so we're suing you for trademark dilution. And Mercedes could sue the Mercedes Computer Company and claim that Mercedes, as it relates to computers, is diluting the Mercedes Car Company brand, and they must immediately stop, or the computer company must stop using that. So the analysis is very similar. Is it confusingly similar? But we have to ask two questions. First, if it's not so similar the public thinks it's the same company, is it so similar that it's somehow diluting or harming the reputation and the brand and the intellectual property rights of a company that has a registered trademark or has trademark rights? So, back to the question. Can you use a mark for your trademark if somebody is already using it for a service or they have a service mark? Yes, you can, as long as it's not confusingly similar and it's not harming their brand. They don't have some big brand that would be harmed by that. No, you can't if it is confusingly similar. Now you might say, how do I know if it's confusingly similar? And admittedly, all the experts will agree, there's ambiguity in the law, and that's the nature of this area of law. There is no perfect way to have a bright line answer and go, oh yeah, that's confusingly similar, or that's not, in these shades of gray. So, who decides, you might be wondering? The finder of fact. In other words, if there's a lawsuit between Mercedes Car Company and Mercedes Computer Company, and it goes before a judge, the judge decides. The judge would be sitting as the finder of fact. The judge would decide, is this confusingly similar? Now, if there's a jury, then the jury is the finder of fact. The jury would decide, are the two marks confusingly similar? This is a pretty high level. If you're interested in more information, you can see the link in the description below to my website at aaronhall.com. If you'd like more educational videos like this, you can subscribe to this channel. And please see the disclaimer below. I highlight these issues as general education, not as a substitute for getting legal advice. So it is important to talk to an attorney in your jurisdiction if you have actual legal issues that you're dealing with. Thanks for joining me here today. I'm Aaron Hall. I look forward to seeing you on the next video.